Hello, I'm Chris Burrell, President of the Magic City Bar Association. Thank you so much for joining us for this final installment of our Social Distancing CLE series. This has been a great year for the Magic City Bar, and it's all because of committed members just like you. At the conclusion of the CLE, be sure to do 3 things. First, submit feedback so you can get credit for attending the CLE. Second, renew your membership. Third, send an email to 5 friends asking them to join or renew as well. Lastly, be sure to join us for our annual meeting later this afternoon so you can be in the know about what's going on with your organization. We will now turn it over to our CLE presenters. Happy holidays.
Good morning. Good morning to everyone. Let me just introduce myself shortly. My name is Emory Anthony. I practice basically criminal defense here in the state of Alabama, and I'm glad to be with you this morning to talk about what I call why you must voir dire the jury. One of the most important things that I believe that we overlook sometime when we get in a courtroom and getting ready to go to trial is that we forget that the jury is the decision makers in our case. And so many times we get up and we have about 5, 6 questions and maybe 10 questions that we do for the jury. And we forget these are the people that are going to make a decision whether or not your client is not guilty or whether or not it's a mistrial. So what I want to do today is just go over a few things and talk about why I think it's important in the early stage of the trial to make sure that you talk to the jury. And I always say that there's 3 times that you get an opportunity to do your closing. One is in voir dire, opening statement, and in the final closing. But so many times we forget about jury selection and how important it is. So I want to talk to you for a few moments, and I'm going to be going in and out. I think at 10 o'clock, I may have to call one of the federal judges to get a status, but hopefully it won't last long and we'll be able to continue. Mr. Burrell has agreed to pinch hit if I have to leave, so hopefully we can get through this. But let's talk about some things, and I don't know whether or not you can talk back with me during this section, and I'm sure you can, but I want to talk about jury selection. You have to remember one of the first things that transpire when that panel comes into that courtroom, they're looking at you, they're looking at your client, they're trying to figure out why they're there, what type of case it is. And the first thing the judge, after she or he says, good morning, they said, this is a case of the state of Alabama versus your client. This is a criminal case. This is a case either dealing with the extreme from capital murder to rape or whatever. And you have to watch the faces of the jury. that panel that is before you. Sometimes they give you the indication that they don't want to be there. And sometimes they give the indication that they want to be there and they want to be on your trial and they want to make some decision. So it's very important that you, as the attorney, start figuring out how I'm going to get this jury to become neutral and listen to the facts of my case. One of the things that I always try to do when I first get up, because the state of Alabama is going to get up and start their voir dire and start asking different questions about uh, beyond a reasonable doubt, whether or not you can be fair to the state of Alabama. And they usually say both sides, but they're going to say the state of Alabama. You need to start thinking before you even get to trial. And I say it's preparation that starts the day you interview your client. When you start interviewing your client and your client is telling you about what has transpired, what he or she is being alleged to have done, you get a concept, an idea about the theory that you're going to present to the jury. And voir dire is, and I call it voir dire, and some call it voir dire, but voir dire is the first place that you start getting your theory out to this jury. Certainly, you want to make sure you select a jury that is not biased, a jury that you believe is not going to listen to you, because you won't believe this, but sometimes that panel comes in that Monday morning saying, I want to do a criminal case. I want to make sure I get some criminal off the street. So your job is to make sure you kind of bring them back into the middle. And one of the things that I always try to do, I first get up, I will talk to him and say, good morning. And I would tell him, on behalf of my client, Mr. Smith, myself, and his family, we want to thank you for being here. We understand that you made a sacrifice to be here to serve on this jury. And this is one of the most important decisions you can do each and every day, except for serving in this country, as in the Army or some armed service. You want to thank the jury, the panel. You don't know who you're going to select, but you want to thank them for coming in and being a part of this legal process. You want to let them know that this process could not happen and go forward without their presence. You want to let them know that as the defense attorney, you want them to be there. You want them to be able to make a decision about the case that they're getting ready to listen to. I always try to start off with questions where I know they're going to tell me no. And I start off with, is there any member of the panel that believes simply because my client have been indicted, he must be guilty of something? Now, there's nobody's going to raise their hand and say yes. Every now and then you have some people that may have been victims of crimes, may give some indication and start raising their hand and say that I believe that he's done something. But that's an opportunity. Take that as an opportunity if someone raised their hand and said, well, yeah, I believe he's done something, because they would not charge them with an indictment. That's an opportunity for you to start lawyering by saying, you do understand that the grand jury, we're not present. I'm not there to ask any questions. My client is not present. Only the state of Alabama and their witnesses are present in the grand jury. This indictment is not an indictment that said that he's guilty, and the judge just told you. And 9 times out of 10, if the judge read the indictment, they will tell the panel that the indictment is not evidence. So you want to remind them of that. You're still trying to get them back to the middle. You want to remind them that the indictment is not evidence. So you want someone to raise their hand. You want the opportunity to share with them why the indictment is nothing more than a piece of paper, a vehicle, as we all say, that gets us from out of district court after 14 days to someone making a decision whether or not probable cause exists to indict somebody. I follow up with, is there anyone on the panel believe that this is Mr. Smith's case? And they probably look at you and say, well, yeah, this is Mr. Smith's case. No, you want to take that opportunity and say, no, this is the state of Alabama's case. This is not Mr. Smith's case. The state of Alabama went before a grand jury and said that they have enough evidence to convict Mr. Smith beyond a reasonable doubt. So this is not Mr. Smith's case. This is the state of Alabama's case, that their burden, and then we start talking about the burden of proof. That's the opportunity to segue into the burden of proof, that they have the burden of proof. It's their burden to prove Mr. Smith guilty beyond a reasonable doubt. Now, usually the prosecutor will get up on voir dire and say that beyond a reasonable doubt is just what it said. It's not 100%. It's not everybody got to beyond any doubt. But you want to take the opportunity once again to say it's beyond a reasonable doubt. You want to let the panel know that if it's one reasonable doubt, that's sufficient. It doesn't have to be 99. It could be just a reasonable doubt. They have to prove their case beyond a reasonable doubt. And you want to let them know that that's their bar, that they have to hold the state of Alabama, since it's their case, the state of Alabama case is their burden of proof. And they have to prove that beyond a reasonable doubt. And you want to live with that A, because there's one. If any of you have a sound and sensible reason for doubting, then that's a reasonable doubt. So you want to keep them there. And then you want to go one step further and say, because it's the state of Alabama's case, because it's their burden of proof, is there anybody on the panel that believe that Mr. Smith have to prove that he's guilty? And you're probably not going to get his hand. And you're going to say, well, that's great. Because the law presumes, and that's when you get into presumption of innocence, the law presumes that Mr. Smith is innocent. And you just don't want to stop there. You want to tell them that the presumption of innocence is a fact as if it came from the witness stand. And the judge is going to tell them that. And that's why you need to find out what the instructions are going to be, because you want to articulate in voir dire some of the things that the judge is going to tell the panel that will become your jury. And she's going to tell them, or he's going to tell them, that the presumption of innocence is a fact of evidence that you take back to that jury room. So you go back to, well, yeah, the burden of proof is on the state of Alabama. The state of Alabama is their case. My client is presumed to be innocent. And then you want to ask that magical question, because you have done your homework, and really you shouldn't make a decision until the state has presented all this evidence. But you have to talk about, is there anyone on this panel that must hear from my client in order to find him not guilty? And hopefully nobody would say anything, but you want to go into, yes, because the law says that my client has a constitutional right not to put on any evidence. Why? And you go back to, because he's presumed to be innocent. Then you say, because it's the state's case. And whose burden of proof? You just go back to your elements of, it's the state of Alabama's case, their burden of proof. The defendant, I usually don't call him the defendant, I call my client by name, that Mr. Smith does not have to present any evidence, and he does not have to take the witness stand. But you want to ask them one other question. You want to ask him, will anyone go back in the jury room and say to one of the other jurors, well, Mr. Smith must be guilty because he didn't take the witness stand? You want to stay on that for a few moments. If you're not going to put your client on, you want to explain to them why it's so important that you understand when you enter the jury room, you're not talking about Mr. Smith not taking the stand. And the judge is going to instruct you. You get back to the judge's instructions again. She's going to instruct you that Mr. Smith has a constitutional right not to take the witness stand. So you want to talk about that and explain that to them again. You also want to make sure that you talk about credibility of witnesses. You want to let them know they're the trier of the facts. They're to judge the witness, especially if you know you're going to have a witness that have changed his or her statement. You want to talk about credibility. You want to ask them, how do you determine the credibility of a witness? And then you want to explain to them, you consider what they say now, plus what they said at another time. Because you want to explain to them, you don't know these people. That's why we're going to select one of you, because you don't know anybody and you're not part of the case. So you want to talk about credibility, why they have to look at a witness, consider whether or not they're lying or they're telling the truth. And you want to ask them, can they do that? Can you use your common everyday sense and deliver and consider whether or not you should believe a witness or you cannot believe a witness? Then after you leave the credibility of a witness, then you want to start talking about some of the prior jurors' experience. You want to talk to the jury about whether or not any of them have served on jury duty before, whether or not they have served in criminal cases. Some people ask about civil cases. I basically try to ask about criminal cases because I want to find out, one, have they served on a criminal case? Two, were they the foreperson? And three, what was the verdict? You want to find out what the verdict is, because you want to, in a short period of time, and this is amazing, and no more than an hour, we have to look at almost 33 people and make a decision who we try and exclude and who we want on our panel for to make the decision. And that is so important. So you want to know some things about them. You want to know their prior jury service, whether or not they have served on a jury, a criminal case, whether or not they have convicted anyone. You want to know whether or not this particular panel have a family member or a close friend that has been a victim of a crime. That's very important, because if you're dealing with a criminal case, whether it's theft of property, robbery, whatever, you want to know whether or not anybody, a family member, close friend, or them have been involved as a victim of a particular crime. And you want to mark that down, because you're taking a survey of who you were trying to exclude, and who is, and this is one case where the person that get the most points, where you marking down one for prior jury service, conviction, one for something else, who gets the most points, you want to exclude them off the jury. Another question you should ask is there any member of the family that have had, member of a family, close friend of them, that have had any type of training in the field of law enforcement, and include a law degree and all this other legal training? That's important, because you have to decide. Sometimes we have lawyers on a jury panel, and you have to make a decision. Do you want someone with legal training to make a decision about your case? Now, there are times that you may want a lawyer on your case. Someone, depending on what type of case it is, a fraud case or something where you trying to show that your client didn't intentionally perform any illegal act. But I would be very careful of leaving a lawyer on the case, because one thing about lawyers, they once they get on there, they're gonna take over the case. They're gonna take over the jury. They're gonna be the leader, and 9 times out of 10, they're gonna be the foreperson of that. So you have to be very careful about that. If you're dealing with a case that deals with that's dealing with something of murder or capital murder or rape or some child case, you have to be very careful and talk about sympathy. Will you make a decision based upon sympathy, bias, speculation, or prejudice? I think it's very important. You need to ask that question, because you want to go into talking about that we all are against people killing one another. We sympathize with the family member. We know the family member is going to take the stand, and someone's going to cry as they identify this victim that was killed. But you're asking them not to put that totally aside, but not to make a decision based upon sympathy, not to make a decision based upon speculation, not to make a decision based upon bias, because we're all against people killing one another. But can you make a decision simply based upon the facts and evidence, and hold the state of Alabama to their burden of proof of proving the case beyond a reasonable doubt? Then you want to talk about, if it's a child, that is very difficult. Dealing with child cases, child sex case, where someone is charged with touching a child without any other scientific evidence. You want to be very straightforward by asking the particular panel of jurors, prospective jurors, is there anyone is so sympathetic to a child that you cannot listen and be fair and hold the state of Alabama to the burden of proof beyond a reasonable doubt? Because generally in a case when it's dealing with a child, the first thing the jury, based upon my experience, when they get back there, they're going to ask the question, well, why would the child come up here to lie? So you have to be very careful about how you structure your questions concerning a case that is dealing with children, because those type of cases, you can turn a jury off quickly by talking about you don't believe a child will lie. The best way to talk about it is whether or not you can consider whether or not a child has been influenced by someone else, that someone else has a reason to influence the child. If it's dealing with a mom and dad and the mom has filed charges and they're divorced and they're going through a heated action, will you consider that the mother could have or may have given the child a reason to say that the father touched him? And that is you have to be very careful with that. And you want to go one more step. Since it's a child, could be a rape victim, could be someone that's a victim that has been shot, will you give me the opportunity to cross-examine that witness? You want to ask that question. Will you give me the opportunity? My job is to represent my client. Will you allow me to do my job to cross-examine the witness without you getting upset? I'm not going to try to attack her. I mean, this is voir dire. You want to be able to give them the impression of what's going to transpire, how you're going to handle the witness, but you want to make sure that they won't dislike you for asking a 8-year-old child, where were you when the man touched you? Was anybody present when he touched you? Did you tell anyone immediately there? Because you have to ask those questions. You're representing Mr. Smith, and Mr. Smith freedom is on the line, but you want to let the jury know early on that this is going to happen. You want to talk about police officers. If police officers going to take the stand, you want to ask the question, is there any member of the panel that believe that a police officer don't make mistakes, that they're perfect, that they won't, and I always do this, they won't fudge with the truth. In other words, you're trying to set the stage that a police officer may be fudging the truth, may not be telling everything. So you want to get that in the mind of these these potential jurors before they get on the stand of what your case is going to be about. If a detective or police officer is going to testify and you believe that the police officer is kind of fudging the truth, you need to ask that question to the jury, whether or not they would just automatically believe a police officer. I also like to ask the question, because 9 times out of 10, I'm representing someone African-American, whether or not race will be an issue in your decision. You want to ask that question. And 9 times out of 10, almost 10 times out of 10, all the panelists are going to say no. And you're going to say, I know, I generally say, I know that is true, but I needed to ask that question. Because you want them to know that you understand that race is always a question when you're dealing with a jury. I don't care what you say, race is a question, good or bad, that they're going to make a decision about. But you want to put it in their minds that, will you make a decision based upon race? This Black individual who's charged with shooting or robbing this white person, will race be an issue? Will you make a decision not based upon the facts that the state is giving you, but based upon that the person is African-American? So you want to get into that. You also want to ask about, is there any member of the panel that know anyone in the district attorney's office? I've sat through several voir dires, and it's amazed me that some lawyers won't ask that question. You want to know. And it's amazing the number of hands will go up of who knows somebody in the DA's office, attend church together, went to high school with them, or they attended college together. You want to know that, because once again, this panel is making a decision. 12 people out of that panel will make a decision. And we have to be realistic. Anytime you're dealing with people, human beings, we all have biases. Now, if somebody tell you they don't have a bias one way or way, they're lying to you. We all have bias about certain things. And we have friends that if we make a decision, we don't want to face them if we're going against them. So you want to make sure you can identify those individuals early on in your decision when you talk about whether or not you know anybody at the DA's office. I go one step further now. I ask whether or not anybody know any of the judges in Jefferson County or throughout the state of Alabama. You want to know whether or not someone talked to judges and they, would share with them. I had a defendant in the courtroom. He was guilty of something, but this jury found him not guilty. You want to know that. Now, before we go into the facts of the case, you know, and I know that you can strike someone for cause. In other words, if an individual has a particular decision in their mind that they've all made up. On capital murder cases, we see that all the time. People say, I can't sit on the death penalty case. I don't want to come back with a recommendation. So they're struck for cause. We've seen on murder cases where there have been family members have been killed and someone close to them have been killed. And they said, well, I can't sit on this case and be fair. Well, you strike them for cause. You ask the court, and 9 times out of 10, the court will take them back, not in front of the panel, but take them back in the court's room, where the judge's chambers, and we'll go over them whether or not they could be fair and listen to the law and make a decision based upon the facts and the law. And some of them will say no, based upon my cousin getting killed, my sister getting killed, my father getting killed. Well, I can't be fair in this. I shouldn't sit on it. So they will be struck for cause. So you have to be able to sit down and identify people that you think for cause. Now, one of the biggest mistakes that we all do in Voir Diary is asking a person like they know Danny Carr, and we ask the question, well, can you still be fair and impartial that you know Danny Carr? And they'll say yes, and then that's it. And once they say they still can be fair and impartial, the judge is going to say, well, they told you they still can be fair and impartial. You want to go deeper into the question to find out how often do they talk to Danny Carr? Do they visit Danny Carr's home? Did they grow up together? You want to show some type of bias to the point that they could not be fair to your client in making a decision. So those are some of the first questions that I try to ask concerning the burden of proof, presumption of innocence, whether or not prior a victim of crimes, whether or not you know anybody in the case. Also, don't allow, and we make this mistake, we should get the witness list and go down the witness list and ask them, do they know any of these witnesses? I know they won't be there, but you want to know by name, do they know them, know of them? Can you still sit on this juror if someone that you know is on this witness list and will be testifying? Can you still be fair? Can you weigh their credibility? Are you so close to them that you would believe if they tell you something that they're truthful, even if we cross-examine them and show that they have made a mistake? You want to make sure those things are done. And the final thing that you go into, and because I'm gonna have to leave in a few moments, the final things that you have to go into is dealing with direct and circumstantial evidence and the facts of your case. And I'm gonna hit the facts of your case quickly. If there's a negative in your case, in other words, your client gave 5 or 6 statements, you might as well go ahead and ask them about it. Can you consider whether or not my client is being truthful, although he gave several different statements because he was fearful? Will you weigh each and every one of them and make the decision whether or not he's been truthful? Whatever is negative against you, you need to go ahead and ask this panel about it before they are sitting down. It's too late once they get sworn in. You need to find out before they get sworn in. If you know they got DNA on your client at a particular place, you need to ask about, will you consider whether or not the DNA was placed there 6 months, 5 months before, that they can't show when it was done? You must deal with it, because when a jury hears it for the first time, they believe that they've caught you in a lie. And the most important thing, your credibility as a trial attorney. Whatever you represent to this panel and to the jury, it must be truthful. The worst thing that can happen is that they find out that during the course of the trial that you have lied about something. So you want to make sure that whatever you say to them, that you can back it up, and without any reason, don't misrepresent, don't forge the truth. Mr. Burrell, I'm going to take a leave for a few moments and see, can I talk to Judge England? Will you take over for me?
Absolutely, Mr. Anthony. Thank you so
All right.
much. And if you don't get to come back, want to thank you again for your time. Really appreciate it, and we really enjoyed the amount that we were able to share with you. So thanks again.
Thank you.
All right. Okay. All right. Hello, everybody. I'm Chris Burrell. As you can see, I'm not Victor Revel, even though I'm often confused for him. People see us all the time and confuse me for him or him for me. But unfortunately, Victor is ill and he's not able to join us this morning. So I've practiced criminal law as well here in Birmingham, and I have a great deal of trial experience. So I'm going to come in and share my insights at this point. Let me adjust my lighting a little bit, make sure everybody can see me okay. All right, so the second part of this CLE is supposed to be about theories and themes in criminal defense and in voir dire. I just kind of want to go over some things that I'm sure everyone pretty much knows, but it never hurts to reiterate the information that we have. First and foremost, a case theory. A case theory, as you know, is basically what you think the case is about. And so there are three parts to a case theory, to an effective case theory. You have the legal theory, you also have the factual theory, and then you have the persuasive theory. Those are all three elements to your to what creates an effective theory. Let me kind of go over those and break them down just a little bit. The legal theory, that's the law that entitles a verdict in your favor. And that can be statutes, that can be jury instructions, that can be anything that is legally based as to why your side should win the case, or specifically as why there should be a verdict in favor of your defendant. Secondly, you have the factual theory. The factual theory, that's simply what happens in the case. The facts of the case as painted by your side. As Mr. Anthony was mentioning before, this is not your client's case. This is the state's case. So they're going to put together, they're going to put forward what they allege to be their facts of the case. But you also have to put forward your facts of the case, or what you believe the facts of the case to be. And that's very important. And I'm going to actually illustrate that a little bit later when I share a actual trial experience that I had. Lastly, you have to look at the persuasive theory. Now, the persuasive theory is very interesting because this is where you really get to be a lawyer. With the persuasive theory, you're trying to appeal to the jury's sense of what constitutes fairness and justice. And probably a good way to do that is to identify who's the hero and who's the villain. That's something that we all grew up getting to know, from Saturday morning cartoons to, little boys or even possibly little girls who like wrestling. There's always, or typically there's always a hero and there's always a villain. So you want to try to identify those two things as well, and help to determine why there should be a verdict in your client's favor or your defendant's favor. So those are the three parts that summarize or that constitute what makes a good theory for a case: the legal theory, the factual theory, and the persuasive theory. And then next you have the theme. The theme is one sentence that summarizes a critical point in your theory, and it sticks out in the jury's mind. Of course, the all-time theory, at least for me, the all-time theory is, if it doesn't fit, you must acquit. And for everyone who remembers, I know there may be some younger lawyers on this panel. On this CLE. But for everyone that remembers, this is from the O.J. Simpson trial, and this quote was made by Johnny Cochran, one of the all-time great criminal defense attorneys, trial attorneys. And this was a critical point in the state's case against O.J. Simpson. They had found what they alleged was a bloody glove that was left there by O.J. when he committed this crime. And they were saying that, he left this glove there, and this proved that he was there and he committed the crime and all this stuff. Well, they had him try on the gloves, and the gloves were too small. Now, I understand there was some lawyering that went into that. I've heard theories like, they had OJ not take his arthritis medicine so that his hands would be swollen. I've heard all kinds of theories about that. But ultimately, what happened, if everyone remembers, when they tried on the gloves in court in front of the jury, the gloves didn't fit OJ's hand. So that blew their whole theory out of the water. And of course, Johnny Cochran came in and perfectly summarized, if it doesn't fit, you must acquit. And as we all know, that's what ended up happening. OJ was ultimately acquitted. So that, now it doesn't always have to rhyme. Let's make sure we get that understood. The theory does not always have to, I'm sorry, the theme does not always have to rhyme, but it does need to be something that encapsulates a critical point in your case or even on the state's case. A couple of things about themes that you may need to be aware of is, one, you want to try to make sure that you have a theme that can't be flipped on you. I'll never forget when I was in college, we were doing mock trials, and one side always used, there was a case, of course this is a fictional case, but there was a case where one guy killed his friend, and they always used the Grapes of Wrath, the story between Julius Caesar and Brutus. And at the end of the day, somebody came back one time and flipped that theme, and they were saying like, this guy is not Julius Caesar, he's Brutus, or the other way around. I'm sorry, I can't remember. I think it was Julius Caesar. But the point is, you want to really think about your theme from all sides and make sure that it can't be flipped on you. So what I wanted to do was just share an actual trial experience that I had, and kind of walk through the elements that we just talked about. So when I first started my criminal defense practice, my trial career, I started off on a hot streak like you wouldn't believe. I think I won like my first 10 or 11 jury trials. And so, I was really feeling good about myself, and I did mock trial all through college and in law school. So I was really, really indoctrinated into, theories and themes and all that kind of stuff. I gave it a lot of thought. I came up with some great themes, some great theories of cases, but this one in particular was one that it was quite a challenging experience, but we ended up getting a great result. So I had this client who was charged with burglary and assault. All right, so let me kind of give you all a narrative about what the state's case was, and the narrative that we put forth, and then the theory and the theme that we put forth as well. So the state's narrative is this: my client, the defendant, went to his ex-wife's house and beat up her current boyfriend. Okay, went there at 2:00 in the morning, beat up her boyfriend. So they charged him with burglary and assault, and these were both felony cases. Now, this was the one time where I was like, okay, I think this case probably needs to settle. However, as we just talked about, putting forward your facts of the case, there were some very nuanced facts in this case that ultimately led us to be able to get a not guilty verdict on it. Now, you would think that, pretty much they had this guy dead to right if, there was no dispute that he actually did beat up the ex-boyfriend. There was no dispute that it happened in his ex-wife's house. There was no dispute that it happened at 2:00 in the morning. That's a terrible set of facts for any case. But in this situation, there were a couple of nuanced facts that needed to come out, and that would, that led to some credence as to why my client should be acquitted. And this is what we put forward. Okay, so my client and his ex-wife, they had 2 sons together. The 2 sons lived with the ex-wife, who had this on-again, off-again boyfriend, who was the alleged victim in the case. The younger son was 10 years old. The older son was about 14 years old. So at one point, the younger son started having nightmares. And this happened for a couple of times over the course of a period of time. And so this one particular time, the older son thinks that they're at home alone. He calls their dad over. So the dad gets up, he rushes over to see about his son. When he gets to the house, the older son, the 14-year-old, lets him in. The dad goes upstairs and he's checking on the 10-year-old. Now, remind you, the ex-wife and the boyfriend, they were on again, off again. it was rare that he was ever there. But this night in particular, I guess he was there. Maybe they were, they decided to meet up or, talk things over, whatever the case may be. So this particular night, the boyfriend was there. The son didn't know it. The defendant didn't know it. And so the dad goes over, he's checking on his son. Next thing you know, the guy comes into the room and they get into an altercation. And it wasn't a terrible assault, but my client did hit him, made a knot swell up on his head or something like that. But it wasn't, like a vicious assault by any stretch. However, because of the circumstances, they charged him with burglary and assault. So the theory that we put forth is that one, all right, for the burglary, for instance, the burglary is that, or the allegation, or what the state would have had to prove, is that the defendant went there and entered unlawfully. That's the first element, and that he remained unlawfully, and that he had the intent to commit a felony therein. Well, first and foremost, he was not there unlawfully. One of the residents of the house, a 14-year-old no less, actually let him in the house, so he didn't enter unlawfully. He didn't remain unlawfully because, again, no one there was telling him he had to leave. The boyfriend didn't have any standing to do so because he didn't live there, and he admitted on the stand that that was not his residence. And then the third element was that he had the intent to commit a felony. Well, his only intent was to be a good dad and go check on his 10-year-old son who's having nightmares. So that theory, that gave us a legal basis as to why he should not be convicted of burglary. And then as far as the assault case, it was simple self-defense. This assault didn't happen in the ex-wife's bedroom. It didn't happen in the living room. It happened in his son's room. So it was clear that the only thing he was there for was to check on his son. And the alleged victim admitted that he came into the room. Now, remember, we also talked about the persuasive theory, how we have to establish who's the hero and who's the villain. Let me back up for just a second. It's very important that you have visual elements that go along with these things. And my client, he was actually late 30s, so he should have known better. But when we got there for the jury trial, my client comes in wearing all black. He's wearing black jeans, black shoes, and a black t-shirt. And he looks just like somebody who would commit a burglary. When you think about burglary, you think about somebody breaking in at night and all this kind of stuff, and he's wearing all black. I asked for a short recess. Now, remember, the Jefferson County Courthouse is downtown. There used to be a Maxway, like right in North Birmingham. It takes you about 10 minutes to get there. I asked for a short recess. I told my client, I said, look, there's a Maxway about 10 minutes away from here. I need you to go up there. They sell these little shirts and tie combinations. Cost you about $15. I need you to go up there and get a white one with a yellow tie. I need you to be as light as possible. I don't want anybody seeing you in all black when you're charged with burglary and assault and beating up somebody at 2:00 in the morning. So that goes to what I'm saying as far as having visuals that match your theory and theme as well. Well, long story short, my client goes up. He does exactly what I asked him to do. He found this shirt and tie combo. It was a white shirt, a white button-down shirt, and a yellow tie. And he comes back, and now he looks a little bit more favorable. I digress. So the theory that we put on is that he wasn't there to cause any assault. He didn't enter unlawfully, anything along those lines. And again, the assault was simply the result of a self-defense, and he got the better of this man who came in. Now, we talked about the identifying the villain and the heroes. Now, my client is there. He's got on a white shirt, yellow tie. He looks like, he looks a little bit less threatening. I'll put it that way. But then we identify him as the hero. He's the great dad who goes over at 2:00 in the morning to check on his son. And we make the alleged victim the villain. This guy has a rap sheet a mile long. He's been off and on with his with the ex-wife, his girlfriend, and they broke up. Another thing is he didn't report this assault until maybe 2 or 3 weeks after the fact. And it was after the girl, the ex-wife, had finally just broken everything off for him completely. She told him, she didn't want to be with him anymore. And so we felt like this was retribution. This was a way for him to get back at and their family. So we identified my client as the hero. We identified the alleged victim as the villain. And we drove that theme home for the entire trial. So the theme that I came up with is the bond between a father and son and a jealous boyfriend who tries to get in the way. And that's all we talked about. Now, to bring it home to how we do this in Voir, as Mr. Anthony was saying, you want to talk about these things from the start. So I asked if there was any single fathers on the binary. I asked if there were anybody who co-parents. These are the things that you want to kind of start to talk about. I asked them about the bond between specifically the fathers. I asked them about the bond between them and their sons. I asked them about how they manage when their ex-wife or ex-partner gets into relationships. All of those things. And then I asked them, what would you do if somebody tried to get between you and your son? All of these things. And right from the start, we're talking about all this stuff. So the jury's kind of getting an impression about what this case is about, who my client is, and all of those things. And so when we get into the actual trial, after we struck the jury, we get into the trial, the first thing we start talking about, or the very first thing out of my mouth is, this case is about a bond between a father and son and a jealous boyfriend who tried to get in the way. Or a jealous boyfriend who tried to come in between. And so that's what the whole trial was about. So when I cross-examined the alleged victim, the jealous boyfriend, I talked about one, his criminal history, because he had a lot of things in there that were directly relevant to his ability to tell the truth. He had obstructing justice cases, all kinds of stuff, theft cases, forgery. He had all kinds of stuff. We talked about the fact that he was no longer with this lady. We talked about the fact that that she wanted to be back with her ex-husband. As a matter of fact, we even got her to testify, and she talked about what a great dad my client was, and all of those things. And she talked about the fact that the alleged victim didn't live there; he just happened to be there that night. All of this stuff. But the real key was their 14-year-old son. We actually had him testify as well. And he talked about what a great dad his dad was and how he always came over to check on them. And that was not the first time he had been over there. He talked about all of this stuff. And it just completely blew the state's theory out of the water. And ultimately, we came back, we got a not guilty on all counts. And like I said before, going into it, it was not a good set of facts at all. But when you flesh out the theory and you flesh out the facts of the case, and then you go through the analysis about developing identifying the legal theory, the factual theory, and the persuasive theory, we hit all of those elements, and ultimately we were able to get a not guilty. So that's just kind of an illustration about how these things can kind of work together, and why it's very important that you start to do it early on. You have to have a clear and concise theory of the case. You have to have a clear and concise and memorable theme of the case. And ultimately, at the end of that trial, like I said before, the theme was, this is about the bond between a father and a son and a jealous boyfriend who tries to come in the way. By my closing argument, I had actually flipped it a little bit and changed it. I said, this case is about the bond between a father and a son and a jealous punk who tries to get in the way. And everybody on the jury just ate it up. And, it's rare that you get to see somebody who comes into court as an alleged victim and they're the sympathetic figure. But by the time it's over, the jury hates them and they want to find for your guy. But that's exactly what happened in this situation. So that's why it's critical that you develop a clear and concise theme. Clear and concise theory, and you develop a clear and concise and memorable theme. So that's really all I have. Just wanted to give you all that quick story about that and to kind of drive home these points. I think that there are some questions in the Q&A session, so I'm going to go in there. Let's see. Okay, Jacinda Anderson asked, do you put clergy on the jury since they believe in second chances? Actually, I have put clergy on the jury before, and I didn't know that I did it, but it ended up being a very favorable outcome for us, because this particular clergyman, he referenced. All right, let me give you the situation. I had a situation where I had a guy who was he was accused of assaulting his stepdad. They were at a family barbecue. They had a long simmering bad relationship. And apparently the stepdad had gotten a little drunk and he was saying some things. And I guess it brought up a lot of bad memories for my client. My client punched him. Well, nobody else apparently saw this. Like nobody else at the barbecue saw it. And so my like I said, when we struck the jury and everything, I didn't realize that this particular guy was a clergyman, but he held out for the longest time because the biblical scripture where it says the facts must be proven by two or more witnesses. And I thought that was very interesting. It was something I never thought about before, but this particular clergyman really held out, and he held steadfast to that. And ultimately, we ended up getting a mistrial because he just would not fold on that point. So I thought that was very interesting. So after that, I actually started implementing that into the questions that I ask on the jury. I'm sorry, questions that I ask during the impaneling. Like, do you believe that there should be more than one witnesses, or do you think that one person's word in and of itself is enough to establish a set of facts? So to answer your question, Jacinda, that can be favorable for you, but you have to make sure you ask that question up front and make sure you ask it right away. Okay, Judge Barron asked, do you speak to your jurors after the trial? And if so, what do you learn from them? Absolutely, Judge Barron. I always talk to jurors after the trial, the ones that will. And what I've done is I've kind of gotten this down to a science. I know, basically after the trial, after they give their verdict, they're going to go back to the jury room. They're going to gather up all their stuff, and then they're going to get ready to leave. So most of the time, they'll come out in large swaths. They'll come out in large groups. So you may catch. One time I was able to catch the entire jury. It tripped me out, but I was able to catch the entire jury, and I give them this little spiel like, hey, my name is Chris Burrell, and I was the attorney on the case, and I would really like to get you all's opinions, and this is win or lose. I would really like to get you all's opinion on things that you impressions that you got from the case, things that you liked about it, things that you think I can improve on. And I'll also tell them, you're not required to talk to me at this point. Your jury service is over. We really appreciate it, but I would really like to get your input so that I can keep improving as a young attorney. And you will be amazed that people will stand there and they will talk to you and they will tell you things that never crossed your mind, because we look at the cases from one perspective, and we try to be open-minded about how people are going to perceive things. But the fact of the matter is, you never really know what's going to happen in that jury room. And so there was one case, and I was almost certain we were going to lose. I had a guy who was accused of beating up and strangling his girlfriend, and we did our whole theory on one aspect of the case, and then after the first day, the district attorney came back with more evidence, and it was like these pictures, and the alleged victim's eyes were bloodshot red, and I mean. And this was crazy. Like, she actually said to the judge, she said, I don't know how I didn't turn this over, and maybe I did it on purpose. And I was like, what? Did she just say maybe she did it on purpose? But the judge would not declare a mistrial. So we had to go forward with it. But long story short, we ended up getting a not guilty verdict in that case. But the whole thing was, my client told me that she had attacked him and that he was trying to fend her off, and he inadvertently poked her in the eye. Well, that would have made sense for one eye being red, but when we got those pictures, those eyes were red, and they were saying that was because of strangulation. And so that just blew my whole theory out of the water, but we persisted with it. Like I said, the judge wouldn't declare a mistrial, which surprised the hell out of me. But we ultimately ended up getting a not guilty verdict in that. I talked to the jury afterwards, and one man in particular told me, he's like, we just couldn't convict him. I was like, really? And he was like, he was just too nice of a guy, and you just did too good of a job. And I was like, wow, okay. So back to your question, Judge Barron, I always talk to the jury, and I would recommend this to everybody. Get a little spiel together. Hey, my name is such and such. I was one of the attorneys on the case. Thank you for your service. You're not required to talk to me, but I would really like your input on what you considered, and things that you would like to share with me. So that is critical, because that's the only way you're going to get better as an attorney. Strongly recommend it. Okay, that's all the questions that I see. I think there are some comments in the chat section, so I will see if that's a question. Oh, Tim Shelton. Hey, Tim. Tim said that there would be certain denominations I'd avoid, to be honest with you, and that's probably true. I mean, I don't know a whole lot about the different religious denominations or sects or whatever the case may be, or what everybody believes, but that's where your radar comes in. You have to be as thorough as you possibly can. And like I said before, I never really considered the fact that people would look at a certain set of facts and say that their religious belief prevents them from establishing these facts based on one person's claims or whatever. But that is something you need to incorporate going forward, just as you hear other things about different denominations or sects or whatever. Make sure that you incorporate those going into your veneer as you impanel juries going forward. We call this the practice of law, and that means that it should be always evolving. Well, let's see. Let me see if there's any other questions, and if not, then we may get ready to go ahead and end this. Okay, if anyone else has any other questions, go ahead and drop them in the chat or in the Q&A, and I'll try to go ahead and get those answered. Well, I'll tell you what, since I'm really multitasking right now, let me see if I can drop this message in the, I'm going to drop a message in the chat right now. And I'll also remind you all as well, it is very important that you provide feedback for these CLEs, because that's how you get credit with the state bar. These are virtual CLEs, so in addition to providing your feedback, you have to also attest that you attended the CLE virtually, so that we can submit that to the state bar. Also, please do it as timely as possible, because it's the end of the year, and we're trying to go ahead and get all the feedback and everything wrapped up so that we can send these to the state bar. So it's 10:27. We've gone for a solid hour. I no longer see any questions. Okay, Ashley Bell asked a question. Will this be available for playback at a later time? It absolutely will. All of our CLEs are uploaded to the Magic City Bar Association's YouTube page. It usually takes us about 72 hours, because there's a lot of things that we have to do once we wrap up a CLE, including downloading it from Zoom and all of that stuff, and then uploading it to YouTube. So give us about 72 business hours. That actually is another message that I would have put in the chat if I didn't have to jump on myself to actually present. But give us about 72 hours and we'll get these uploaded to the YouTube page, and you can go back and watch them there. Okay, also Jacinda asked, do you have a second chair, especially during voir dire, to help? Absolutely. It is critical that you have a second chair. As a matter of fact, I make my defendant the third chair. I always have a second attorney with me, just to kind of look at things that, jury reactions when I ask a certain question and all of that kind of stuff. And I'll even give my client a piece of paper as well. And I'll tell them, hey, look, I want you to write down if you see anybody giving you dirty looks, if you see anybody you think if you see anybody you think you may have cut off in traffic, whatever the case may be, I'll ask them write that information down as well. So not only do I have a second chair, I have a third chair. Okay, I don't see any other questions, so I want to go ahead and close out now. I really thank you all for being here. Thank you for your time. I want to thank Mr. Anthony once again for coming on. I also want to thank my buddy Victor Revel. Hope you get better soon. We'll be talking to you next time you're going to do this whole CLE by yourself. You owe me an hour. And lastly, I want to remind everyone, if you haven't already, go ahead and join the Magic City Bar or renew your membership. We're at the end of the year. And lastly, our annual meeting is this afternoon at 6 p.m. So we would love for you all to join. Everyone should have received an email about it already. So if there's nothing else, I want to thank you all for being here. Everyone have a great day. The next CLE will start at 11 o'clock. Thanks again.